I did.
But, okay, it wasn't given to them, though, before your report first went to the judge.
That's correct.
And I understand that attorneys for Mr. Bottini, the assistant U.S. attorney handling the case in Alaska, said he pressed his supervisor on 7 separate occasions to voluntarily disclose impeachment information regarding the possible subordination and perjury by Bill Allen, who was a key government witness, who said, and the other line prosecutor in Alaska, Mr. Gecki, he claimed they moved to disclose that, but your report says that Mr. Bottini and Mr. Gecki intentionally withheld this information and does not and did not try to get it disclosed. So which is which is it? Did they attempt to get their supervisors to disclose information by Bill Allen, or are they not being truthful when they say that on these numerous occasions they asked to have it?
As our report indicates in great, some would say excruciating detail, Messrs. Bottini and Gecki on a number of occasions proposed, indeed urged, the rest of the prosecution team that some disclosure be made about evidence which was in their possession indicating that their star witness, Bill Allen, had suborned a false statement from a young woman who was a crack-addicted prostitute with whom she claimed to have had sex when she was 15 years old.
And this exculpatory information was not made available?
It was not.
Thank you. Senator Grassley.
Your report states, quote, were there a clear, specific, and unequivocal order of the court which commanded the disclosure of this information, we're satisfied that a criminal contempt prosecution would lie, end of quote. Ultimately, your report concluded that no such order existed for Brady or Giglio obligations. However, your report states that at a September 10th, 08 motion hearing, the court, quote, unquote, admonished the government to follow the law, meaning Brady, but that no order was issued that day. As a result, despite the intentional and willful efforts to conceal this material, the prosecutors could not be criminally prosecuted. Question: the fact that Judge Sullivan did not issue an order on September the 10th is arguably the seminal point of this matter because it prevents the prosecutors from meeting the elements of a prosecution for criminal intent. Had the court issued a formal order on September the 10th instructing DOJ prosecutors to comply with Brady and Giglio, would you have recommended criminal contempt against the prosecutors?
I would.
Notwithstanding this technical violation, do you believe they should face criminal penalties, including jail time?
That's not a judgment, Senator Grassley, for me to make.
In the course of your investigation, were you able to determine what the intent of the prosecutors was during the September 10th motion hearings? Well, that's a question, but let me continue. Let me start over again. In the course of your investigation, were you able to determine what the intent of the prosecutors was during the September 10th motion hearing? Did they intend to keep Judge Sullivan from issuing an order so that they would not be subject to possible criminal contempt charges later?
They did not. As a matter of fact, at one point during that colloquy on September the 10th, Judge Sullivan said, well, so what should I do, Madam Prosecutor, addressing Brenda Morris? Should I issue an order that you produce any and all Brady and Giglio material? And the response was, if that's what the court wishes to do, the court may do so. The court, however, concluded that colloquy on September the 10th by saying, I am not going to issue an order. I will accept the professions of good faith on the part of the government. We all know the law. They tell me they know the law. There is no need for me to issue an order compelling them to comply with the law. Hints to the wise should be sufficient.
As a result of this case and going forward, should all district judges issue formal orders to DOJ prosecutors instructing them to comply with Brady and Giglio in an effort to ensure compliance and secure the possibility of criminal contempt?
Well, Senator Grassley, that's one way to address the issue. I'm not satisfied that it is the best way to address the issue. You know, I say in the report during the discussion of whether or not Judge Sullivan had issued an order that no district judge ought to be required to order prosecutors to comply with their constitutional obligations, let alone be required to issue an order so specific that it might support a criminal contempt prosecution in anticipation of its willful violation. That doesn't make any sense to me. It is true that around the country, at last count of which I'm aware, some 38 of the 94 districts have standing local rules which order the production of Brady and Giglio material pre-trial as a part of the overall discovery regimen. That's one way to address it. There are judges individually who have standing orders in every criminal case to the same effect. And indeed,
I think you've answered my question. Let me go on to another question.
yes, sir.
Okay. The Stevens case was prosecuted by two attorneys, U.S. Attorney's Office, Alaska, as well as two attorneys, Public Integrity Section, Maine Justice. In fact, the U.S. Attorney's Office was recused from the case because of conflicts of interest. Thus, the Public Integrity Unit in Maine Justice was in charge of the case, with the chief of the section and his principal deputy significantly involved. They were involved in the drafting of the indictment. They prepared memos for leadership of criminal division, and they briefed the division's leadership on the progress of the case. Numerous emails reinforced the fact that Public Integrity viewed themselves as the final authorities. Indeed, shortly before the case was to be indicted, the front office of criminal justice at Criminal Division, Maine Justice, made the principal deputy Public Integrity the lead trial attorney. Nevertheless, the report seems to minimize the responsibility of the Public Integrity for the failure of the case. The section chief claims, and the report seems to accept, that he was cut out of the supervisory chain of command, and the deputy chief claims that she withdrew from supervision over the prosecution team because she didn't want to cause dissension among the team. Question: doesn't the chief of the section that was in charge of the case bear responsibility for failures? This was perhaps one of the most important cases Public Integrity has ever prosecuted, that of a sitting senator. Why does the report seem to avoid a finding of fault against the section chief of Public Integrity, ultimately responsible for all cases in the section? Shouldn't the buck stop with the boss at the top? If not, why not?
First of all, Senator Grassley, it is not so that the report fails to address this issue. The report catalogs in great detail the history of the management or mismanagement of the case. The report chronicles the fact that both Mr. Welch, then the chief of the Public Integrity Section, and Brenda Morris, his deputy chief, abdicated supervisory responsibility for assorted reasons, some of which you, Senator, just recited. So the report did not shirk from addressing the failures of management. Recall, Senator, that the object of our investigation, as chronicled in our report, was to determine whether or not criminal contempt proceedings were appropriate with respect to any of the named prosecutors. We found no evidence, apart from this failure of management, that either Mr. Welch nor Ms. Morris willfully engaged in any misconduct in the nature of concealing Brady or Giglio information from the defense.
This will be my last question because I want to keep my colleagues going. The report makes the Deputy Chief of Public Integrity seem hapless, overwhelmed. At times, she seemed more interested in not ruffling feathers with the trial team than aggressively supervising the case. As an experienced prosecutor assigned to run the case, shouldn't she have risen above the concerns about ruffling feathers and done the job she was tasked with? And if she was failing, wasn't it the job of her supervisor to fix that?
No question.
Okay, thank you, Mr. Chairman.
Thank you very much, Senator Fox.
Well, thank you very much, Mr. Schulke, for
Good morning, Senator Feinstein.
your work in this area. Both Senator Leahy and I have served on the Appropriations Committee with Senator Stevens. Senator Leahy far longer than I, but I almost 20 years. So in the course of so doing, you learn a little bit about a person that sits on that committee. So it is with a kind of particular shock that we view what happened to him, made all the more worse by his premature demise, obviously, and the fact that he never knew the result of your report, which is a great tragedy. But as I understand the department's policies regarding Assistant United States Attorney, a DOJ attorney engages in professional misconduct when he or she, and this is a quote, intentionally violates or acts in reckless disregard of an obligation or standard imposed by law, applicable rule of professional conduct, or department regulation or policy. Do you make that finding in your report?
I do not address the disciplinary rule, nor do I address the standards that the Department of Justice applies. What I did conclude is that in several instances, two of the surviving prosecutors engaged in intentional misconduct. Therefore, if the department were to come to the same conclusion, or if they concluded that the conduct was reckless, they would perforce conclude that the lawyers engaged in professional misconduct.